thine unworthy servants here gathered today in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above to direct and guide us in all our consultations. And grant that, we having thy fear always before our eyes, and laying aside all private interest, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace, and tranquility of the island, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
This Honourable Senate now resumes its sittings, being the 15th of November, 2019. Before we begin the business of the day, we are joined by quite a few students this morning from the Frome Technical High School. As the young ladies and young gentlemen sitting to the right, to my right, they are accompanied by one teacher. And for those of you who do not know, the Frome Technical High School is in the parish of Westmoreland, from which Senator Gale has some distant ancestral roots. So welcome the students from Frome, and we are also joined by 70 is a figure I see here, but I don't necessarily see that reflected. A number of students from the YMCA. Could you identify yourself? Good. Oh, fantastic. Okay, those are the youngsters in the blue, and they are accompanied by 10 of their teaching staff. Welcome to the Senate, as I say every time that we have visitors. This is your part of your governance. It's your parliament, and you're always welcome here. So welcome again, and if I don't get an opportunity to address the teachers from Frome, please ensure that when you go home, you're going home, that you insist that the operator of the vehicle drives in a manner that is ensuring the safety of these youngsters who are in your care. Colleagues, since we met on the last occasion, three Jamaicans of particular note have passed, two of whom gave service to the Parliament of this country, albeit in the lower house, and I would just ask the clerk to record our sympathies to the families and to make a note on the record of this Parliament that we as a Senate have observed their passing and recognized their contribution to the country. Two members of Parliament and a member of the former member of the judiciary. And I speak, of course, of, first of all, Mr. Douglas Vaz, who was a member of Parliament for the constituency of North Central St. Andrew from 1976 until 1989. Served also in a ministerial capacity, particularly in the Ministry of Industry and Commerce. For those of you who are making a note, his funeral is November the 18th at Stella Maris. And also, not a member of the lower house, representative of Trelawney Northern from 1997 to 2002, and I refer to Mr. Wendell Stewart, who gave service in the lower house as well. And his funeral service is in Falmouth at the Catholic Church on November the 30th at 11 a.m. And I bring also to the attention of this Honourable Senate the passing of Sir Edward Zaka, distinguished jurist who served as Chief Justice of Jamaica from 1985 to 1996, and served the wider Caribbean as President of the Court of Appeal of Bermuda, Turks and Caicos Islands, and the Cayman Islands, as well as sitting in the Court of Appeal in the Bahamas. And he was knighted for his work, presumably outside of the Jamaican jurisdiction. His funeral service is actually today at 1:30. I know that the leader of opposition business, the clerk, and myself, representing the Senate from this side, will be attending that funeral. So I ask Madam Clerk if you would be kind enough to note the sympathies of the Senate in relation to the passage of these three Jamaicans. I know that the leader wanted to say something briefly.
Thank you, Mr. President. This would just be to offer on the part of the Senate and certainly the members on this side to add our words of condolences and sympathy to the friends, families, and loved ones left behind. Although the two former members of Parliament served some time ago, one could also extend to their former constituents, as we understand that both men served with distinction in their areas of, in their constituencies, and were deeply loved by their constituents. Sir Edward Zaka certainly served with distinction in Jamaica and more widely in the Caribbean, as you have indicated, to be Chief Justice for 11 years and then to serve as President of the Court of Appeal and sit on the Court of Appeal in 4 other Caribbean countries certainly signals the esteem within which he was held, the regard in which he was held, and the strength and vigor of his mind. So we add our condolences and sympathies to their families, and of course pray that their souls rest in peace. Thank you.
Thank you, Minister. Senator Scott.
Mr. President, I join with you and the leader of government business in extending my condolences to the family. It was truly remarkable that we lost so many people who had contributed so significantly to Jamaica within very short order. And I hope I'm not being insensitive when I said that the comforting thing was that 2 of them died in their sleep, because it just felt as though they on the same day, and it felt as though they had just made a decision to exit this place at that time. Mr. Douglas Vaz is well known, and I think he has distinguished himself in Parliament. But if you ask the average person in Jamaica, they remember him for his service to the manufacturers. Not only was he president, but he also constantly advocated on their behalf. And I know that will be, that community must feel a deep sense of regret and loss. Mr. Stewart, as you pointed out, only served for 1 term, but his commitment and passion is demonstrated by the fact that he founded a basic school, and it symbolizes to the nation exactly how he felt about education and service, and in a way demonstrates that he was not just about the politics, but he was driven by the service that one could do within the political sphere. It is Sir Edward Zacker with which I'm most familiar. And he was a Chief Justice who was widely regarded and respected. But one of the things that people will say about him is how much he involved others, how affable he was, how engaging he was in his contact with other persons. No haughtiness, no superiority, just a humble, honorable person. And it is quite clear that as a leading legal luminary, other jurisdictions noticed him and sought to make use of his considerable talents. It is never easy to say goodbye, especially when you lose friends and when you lose family. And so again, I ask that we sympathize with those who are mourning and who are in grief, and we certainly as opposition senators, join in extending the condolences to friends and family, if it pleases you.
Thank you very much. Madam Clerk, you'll make the appropriate notes, please. Statements by ministers.
China.
Announcements.
Laid on the table of the Senate today are the following. Ministry Paper number 76, the National Science, Technology and Innovation Policy. Annual Report of the Tourism Enhancement Fund for the year 2018-2019. Annual Report of the National Export-Import Bank of Jamaica, Exim Bank, for the year 2018-2019.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 12th day of November 2019, a bill entitled An Act to Repeal the Minimum Business Tax Act was passed in the House of Representatives. Signed, Pernell P. Charles, Speaker of the House of Representatives.
Petitions.
If you could recommit, Mr. President, as I would beg to take charge of the bill.
I'm very sorry.
A bill entitled An Act to Repeal the Minimum Business Tax Act, read a first time.
Mr. President, I beg to signal that my willingness to take charge of the bill.
Thank you very much.
Mr. President, I also give notice of second reading of the bill.
Thank you very much. Petitions. Papers. Reports from committees. Notices of motions given orally.
Mr. President, I have permission to speak from this seat, sir.
No. Yes. Go ahead.
I was buried. Mr. President, I beg to give notice that at the next meeting of the Senate, I will move the following motion. Whereas there is an ongoing transformative change occurring in the world of work, driven by technological innovations, the fourth industrial revolution, globalization, environmental and climate change, and demographic shifts in labor policies, which has created profound impacts on the current nature and future of work. And whereas it is imperative to act with urgency to seize opportunities and address the challenges to shape a fair, inclusive, and secure future of work with full, productive, and freely chosen employment and decent work for all. And whereas securing the future of work is fundamental to the sustainable development of Jamaica in line with Vision 2030, to ensure effective transitional mechanisms that can harness the fullest potential of technological progress and productivity growth, which includes the acquisition of skills, competencies, and qualifications for workers throughout their working lives. Be it resolved that this Honourable Senate express and commit its support towards the setting of established policies aimed at strengthening the capacity of all people to benefit from opportunities of a changing world of work. And be it further resolved that the Senate call on the government to establish a national commission comprising targeted stakeholders to examine the issues surrounding the future world of work with a view to making relevant recommendations for the institution and implementation of an appropriate policy framework in this regard.
Thank you very much, Senator Gale. Questions and answers to questions?
Yes, Mr. President, thank you. I am aware that in my absence, Senator Brown had inquired as to the questions asked of me and standing in his name on the notice paper. I just wish to indicate that I have some of the information, but it is not complete. I would ask the members' indulgence, but if he wishes, if they are still not complete at the next sitting of the Senate, I can table what I have, and then we can move from there. But regretfully, they are not complete at this time. I ask his understanding.
Thank you. Thank you very much. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. The presentation of bills without the leave of the Senate first obtained. Public business.
Thank you, Mr. President. Mr. President, we have quite a full agenda today, although it we had not anticipated that it would be, in fact, quite so heavy. It's intended to proceed with the Proceeds of Crime Money Laundering Prevention Amendment Regulations, to take the Terrorism Prevention Act designated non-financial business provider order in respect of attorneys at law, and also to open the State of the Nation debate with the contribution by Senator Samuda. Mr. President, it is intended to start with the proceeds of crime, which regulations were tabled on the 1st of November. We wish to which were tabled on the 1st of November and were passed in that other place on November 5th. Mr. President, the regulations before us, and indeed the second item on the agenda, form part of the suite of legislation with which we have been contending over the past two or three sittings, as we seek to ensure that we comply with the FATF guidelines and the CFATF monitoring regime, which essentially governs the anti-money laundering and counter-financing of terrorism regime within our financial system. Mr. President, of course, most recently we passed in this House the Proceeds of Crime Amendment Act 2019, the Terrorism Prevention Amendment Act 2019, and the United Nations Security Resolutions Implementation Amendment Act 2019. We know that we're seeking to ensure that we address the deficiencies that were notified in the mutual evaluation report, which provided suggestions on how our financial systems could be strengthened. Essentially, the recommendations which were put forward, 40 recommendations in total, wherein Jamaica is now having passed the laws which we most recently passed in this chamber and in the lower house. We're partially compliant with 21 and non-compliant with 2, but the regulations before us today will take us down the road of essentially eliminating our partially compliant status, or rather the elements which are partially compliant, and I believe that we will still have some work to be done on 2 or 1 of the non-compliance. But these are technical compliance deficiencies, Mr. President, which must be addressed with urgency, and they must reflect a clear commitment to address our anti-money laundering deficiencies. So, Mr. President, the regulations before us start with Regulation 2. They amend Regulation 2 of the principal regulations by providing new definitions for control, group, and ultimate beneficial owner, bringing the definitions in line with the Global Forum amendments which we made to the Companies Act maybe 2 years ago, and of course ensuring that there's alignment between the regime that deals with companies. It ensures that that regulated businesses will be required to establish risk profiles regarding their business relationships to determine whether they are in fact of high risk. And the determination will not only be limited to the actual applicant business, but to the ultimate beneficial owner. And this generally, Mr. President, is addressing financial institutions who are more concerned with these matters. Group and control, of course, are being treated in the same way, and they will be replicated in the counter-terrorist financing mechanisms. Mr. President, the amendment being proposed to Regulation 3 now provides a specified time, that is 15 days after the end of each month, for financial institutions to report to the designated authority on transactions involving the prescribed amount. And the inclusion of this provision will enhance the capabilities of the designated authority. Amendment of Regulation 5, Mr. President, includes the reference to the size and nature of the business in relation to the assessment of risk, which is an improvement because every business cannot be a high-risk business. So what this does is allows a more managed approach, a simplified approach to ensure that businesses are implementing assessments proportionately to the risk that a particular business provides. So we are here now ensuring that compliance requirements use a risk-based approach so that supervisors and financial institutions and intermediaries they identify, assess, and understand the money laundering or terrorism financing risks to which they're exposed and focus their resources and attention most effectively and appropriately. Mr. President, the fine of $400,000, which was associated with offenses to this regulation, has also been increased to make it more dissuasive. And for an individual, Mr. President, the fine is now $3 million. And for a body corporate, it's 5 before the parish court. And these, Mr. President, are intended to make sure that what is essentially a money-making business, money laundering, it is an illegal money-making business that persons who commit offenses that they pay It can't be that you have light fines for offenses like this, Mr. President. You may as well then not have them at all. Mr. President, Regulation 7 is also amended by these regulations here, which deal with identification processes, business relationships, and transactions. And the amendment now takes into account the application again of risk management procedures while the regulated business seeks to identify and verify the applicant for business. Mr. President, the amendment also provides for issuance of guidelines by the competent authority, which may include limitations on the number or types of transactions that may be performed, and it provides, it may also provide for requirements for monitoring large or complex transactions that are outside of the norm. So, Mr. President, the amendment really considers a situation where there are reasonable grounds to believe that a business relationship is related to money laundering, and that carrying out due diligence procedures might alert the person so that the regulated business will, instead of performing the due diligence procedures, make the required report as provided under the Act. Mr. President, amendment of Regulation 7A requires businesses to establish risk profiles for business relationships and one-off transactions to determine the type of due diligence procedures which are to apply. Mr. President, the regulation provides that the businesses in the regulated sector, in considering the risks, should employ commensurate measures in order to effectively mitigate against those risks. So again, this amendment provides for the regulated sector to apply simplified due diligence procedures to low-risk transactions once a proper evaluation of the risk has been conducted, and this will allow entities subject to the POCA regime also to only require, for example, a government-issued ID and basic information from a particular business if it is low risk, and this will improve the ease of doing business while retaining the rigor of the systems where they are in fact required. Mr. President, there's a new Regulation 7B included. As it stands now, the current framework doesn't provide for the application of countermeasures proportionate to risks. So on the other side, Recommendation 19 of the FATF requires the application of enhanced due diligence measures and other countermeasures for transactions and business relationships from countries identified by the FATF as having weak anti-money laundering or counter-financing of terrorism systems, the very type of designation that we here in Jamaica are seeking to avoid. So there are countries that are so listed. We had looked at that when we were dealing with the amendments to the Act. And of course, we know that there are some obvious ones. I believe one was issued recently for Iran. And there are, in fact, some brother and sister countries who have made their way into what is known as a grey list as well. It is important that we keep ourselves off of these lists. In order, therefore, to protect the integrity of our financial system, the new regulation regarding enhanced countermeasures has been included in this 7B, and it sets out what needs to be undertaken when dealing with entities from territories so designated by the supervisory authority. And this requires the imposing of limits on those business relationships or transactions, providing reports at more frequent intervals, and carrying out additional audit requirements. Mr. President, Regulation 8 is also amended by these regulations to provide a greater level of transparency in the process of granting exemptions in relation to de minimis amounts that may not be subject to customer identification and verification procedures. So the amendment allows the minister to specify the amount and prescribe categories of regulated businesses on the recommendation of the competent authority and the designated authority. Mr. President, amendment of Regulation 9 requires that businesses conduct electronic fund transfers, ensure that they receive and include in their records accurate information through the payment cycle, that they identify and verify recipient funds transferred exceeding US $500, and that they have in place risk-based policies and procedures. But essentially, Mr. President, though, companies that do electronic transfers do retain this information already generally, but it is now being captured in here to make the regime stronger, ensuring that the regime around wire transfers exists. In this regard, the regulated sector would be required as well to apply risk-based policies and procedures for determining whether to reject, execute, or suspend a transfer lacking the required information relating to the persons involved and to establish the appropriate follow-up. Mr. President, Regulation 11, which is being amended here, mandates the identification and verification of the identification of persons purporting to act on behalf of a customer, so their agent. And this amendment will improve the process of identifying the beneficial owner of the property or funds subject to financial business concerned, as well as identifying and verifying the agent acting on their behalf. So this also addresses a technical requirement by FATF, a specific one. Mr. President, Regulation 12 will now have a time period of 15 days to provide more definitive timelines for the provision of identification information in relation to third parties. So this will allow for greater efficiency and improves the process for identification and verification procedures. There was no specific time before, so business could have been unduly delayed as there was no requirement to move any faster than was felt appropriate. Mr. President, Regulation 13, which will be amended, will strengthen the process for the conduct of due diligence of the beneficiary of life insurance or other insurance contracts covered by the Act. Accordingly, Mr. President, the regulation now calls for the regulated business to undertake the identification and verification of the beneficiary of a life insurance. And as we indicated when we were passing the Act, that life insurance is covered because it is the type of instrument that lends itself to being used for money laundering as opposed to other general insurance. And this is why it's being treated in this regard. So one has to ensure that the beneficiary does in fact exist and that the insurance therefore is a valid one. Mr. President, this is to be done at the time of payout, so it will not actually prevent or unduly interrupt the issuance of life insurance, but it will be something that has to be considered at the time of payout, ensuring that there is sufficient information available for verification. Mr. President, this will facilitate risk management, again, specifically especially where beneficiaries fall within a high-risk categorization, and again requires the use of enhanced due diligence procedures. Mr. President, amendment of Regulation 14 enables the efficient investigation of money laundering by strengthening the record-keeping requirements so that regulated businesses are now required to maintain correspondence and analysis undertaken in relation to the transactions and business relationships referred to in this clause. So, Mr. President, this information is to be made available to the designated authority and the competent authority on request within 7 days as directed by that authority, or as directed by that authority. So this is expected to improve the overall record-keeping procedures and addresses, again, a technical deficiency identified in the mutual evaluation report. Mr. President, the amendment to Regulation 18 aims to standardize the application of anti-money laundering and counter-financing of terrorism policies to the overseas branches and subsidiaries of the regulated businesses. This inclusion will allow businesses in the regulated sector to apply measures to minimize their AML-CFT risks and to inform the competent authority concerned. Mr. President, the new Regulation 20 outlines penalties applicable to contravention of certain regulations, in particular 77A, 7B, 11, 14, 15, 16, and 17. There's also a new Regulation 21, Mr. President, which allows for the imposition of fixed penalties on regulated businesses to be enforced by the competent authority. So this is akin to provisions which already exist under the Banking Services Act of 2014, Mr. President, which allows for licensees or allows a licensee to discharge any liability to conviction of specified offenses by payment of a fixed penalty. So it's expected that these administrative sanctions would apply to technical compliance issues only. So examples of offenses for which fixed penalty notices may be served are under Regulation 5, the failure to establish programs, policies, and procedures, Regulation 7, failure to comply with identification and transaction verification procedures, Regulation 14, failure to comply with record-keeping requirements, and 15, failure to comply with requirements for internal reporting procedures. Mr. President, there's also a new schedule to support this regime, which includes a prescribed fixed penalty notice. Mr. President, allow me in closing to underscore the importance of enhancing our legislative framework to address, again, the identified weaknesses in our anti-money laundering and counter-financing of terrorism regime. We know that POCA sets the broad framework and that others align in parts and elements with it, and in this particular body of regulations will take us far down the path of ensuring that when we go to FATF next week, that we will be able to have a credible position on which to seek a re-rating of our of our status and to avoid a downgrading, Mr. President, which is, of course, the most critical requirement. So I look forward to hearing the contribution of colleagues and look forward to their support, recognizing the need to strengthen our systems. I thank you, Mr. President.
Thank you, Minister. Senator Scott Motley.
Mr. President, this is one of the areas in which both administrations have a common accord. When the present leader of opposition was then Minister of Finance, he had pledged his support and the government's cooperation and commitment in taking the necessary steps to make Jamaica fully compliant in regards to these matters. We understand the requirements for having a robust and effective anti-money laundering and counter-terrorist financing system. It was then, when the urgency was upon us, that we actually sought international assistance in areas relating to the coordination of enforcement and regulatory activities, so that there is a clear understanding of the necessity to strengthen our financial legislation, as this is the way in which we will ensure compliance. I, for my own part, must signal my appreciation of the low risk-based requirement, because one has to be sensitive as a legislator to the impact of legislation on institutions and persons. And I'm sure the public is going to be relieved that the requirements have been simplified in a way that they don't feel that they're a criminal at the outset. So I think that that is a particularly good move. Mr. President, as has been stated by the Minister, this matter needs to be concluded urgently. And I am of the view that although some of us did not have the opportunity to scrutinize it in a manner which we would like, I have signaled my cooperation in this regard, and I want to our cooperation. You know, when Senator Brown says that, I am particularly relieved that he joins me as a leader in this statement, and I am sure that those who are sitting here and those who are listening will understand that since I have no whip, when he complies, are you saying that he needs to be whipped? I will reserve the comments until after the sitting. I've been accused of being a mother hen, but not one who brutalizes others. So that I rise only to signal our approval. We support this resolution. We support the amendment, if it pleases you.
Yeah, that has provoked my response. No.
Thank you, Senator Scott Motley. Senator Brown.
Thank you, Mr. President. As the leader of opposition business said, we support the anti-money laundering adjustment. But this resolution has and can have significant impact on the citizens of our country, be they corporate or individual. I see, for example,
In one of the offense, you could get up to 3 years in the parish court, but as much as 20 years in the circuit court. And I'd have loved, Mr. President, to have had some more time to have gone through this resolution, given its potential impact on our citizens. And I'd like to urge the minister and the government side that while we are willing to cooperate with urgent measures, it is important that we also, as government, act in a timely manner which allow the legislators to deliberate properly. I see, for example, that the order was signed on the 29th of October. Could it have been signed earlier by the minister and therefore allow more time for the lower house and this chamber to deliberate? Because having signed on the 29th, it leaves us very little space. I was told by the leader of opposition business yesterday that the leader of government business asked that we add it to the agenda today. Less than 24 hours notice to go through a 24-page set of amendments to a principal regulation to a principal act. It's difficult, and we're going in good faith in supporting the government. But I urge that the government, in setting its own agenda, take into account that we have a duty as a review chamber, not just to rubber stamp, but to look through these issues so we can comment and protect the citizens of our country. Minister, it's good and well that we fit into the international regulations. I'd like to see some of the international regulations be more responsive to the needs of our country. I'd love to see us being able to get not just money laundering, anti-money laundering consensus. I'd like to see a consensus on cannabis, legitimate money coming from the cannabis industry, because that would be key to helping our country as we help other people. Yes, as KD said, this also affects us too, but it affects others much more. But I'd like to see that international community that comes together on anti-money laundering come together and the legitimate use of the cannabis, the ganja industry, because that certainly would benefit us. Especially at a time, Minister, when we're hearing noise about guns, and that we Jamaica must be protecting ourselves against the influx of guns. Others who are talking to us from the international community need to have in regard for their responsibility in stopping the guns coming through our ports, in the same way that we help them in the fight against money laundering. It's very important. And I think also in closing, Mr. President, that as a country, we have to stand up, not just in rushing to meet these anti-money laundering requirements, but we have to stand up for the best interests of Jamaica. We must not be lectured to about who our friends ought to be. We are friends with everybody. We are friends against the against the money laundering people. We are friends against them. But nobody must tell us, no matter how high, no matter how much they paid for their position, nobody must tell us who our friends should be in the international community. And I want to make it clear that I appreciate all developmental assistance, all developmental loans, because for us to carry out these anti-money laundering things, we have to maintain our sovereignty. I must commend the Gleaner's editorial of, was it yesterday or the day before, which says that some colony need to be done. I commend them. That's patriotism, because we are bigger than that. Our history has shown that we have stood up for what is right, from Norman Manley standing up against apartheid, South Africa, to Michael Manley, PJ Patterson, Edward Seaga, Bruce Golding, coming right through, Portia Simpson Miller. We as a country must learn to stand on our feet and tell others they must mind their business, because Jamaica will support what is right for the world, but more so will support what is right for us in Jamaica. So, Minister, thank you, but give us a little more time in future. Get your ministerial colleagues to do what they must do on time, earlier, so that we can do our duty here. I close simply by saying, I look forward to the report on the China trip. I look forward to that report. And believe me, Minister, you know, Minister, when Nesta finish with you. Yeah, but I want through you to the Minister. I want her to know that the government of Jamaica have my support in standing up against bullies of whatever type. May it please you.
Yes, Minister.
Thank you, Mr.
Thank
President.
you, Senator Brown.
And I thank my colleagues for their support of the strengthening of our anti-money laundering and counter-financing of terrorism regimes. It is, of course, being done at this speed to meet a deadline and for compliance, but it is something which is necessary because of our sovereignty and because of our understanding that these matters are in fact in Jamaica's interest. So, and yes, there will be impact on businesses, and they have been monitoring these matters. There are, this is a part of the development of guidelines, ensuring that business processes will be able to be adopted within an appropriate period of time. And we also have to recognize that while we look at expanding the types of enterprises that can be legitimately entered into, like cannabis, that the strength of our financial system and our regime, the stronger it is the more likely that we will be able to effectively advocate, as we already do, for the flexibility to be able to have licit money generated from the cannabis industry also treated within our formal financial system. So the stronger our system gets is the stronger the platform on which we stand in order to lobby internationally for treatment, positive treatment of cannabis industry and the financing of it. So this is all working together for the greater good, Mr. President, and it's not only related to ensuring that the banks monitor in a particular way, a particular type of money. It is making sure the system is strong enough so that any type of enterprise that we're entering into is recognized as legitimate, because the systems will pick up anything that is not. So it is, we are going in a good way, Mr. President, and we are acting indeed, as we always do, in the best interest of Jamaica. And I really do want to just note that, it would be interesting, the advice that I am given, it is interesting to juxtapose it with the understanding that the instructions which are being given in the context of information which is actually somewhat dated and was published to time with a particular action, so that it is all a part, as it appears to me, quite a construct. So I appreciate the guidance which is being given and will only respond that at any given time, I, as Minister of Foreign Affairs and Foreign Trade, act in the best interest of Jamaica, land we love, at all times. And I will not be acting on the instructions of editorials that have been pulled together to carry out somebody else's agenda. So I note the instructions. But I do no more than that, Mr. President. And with that, I close and thank colleagues for their support of the resolution. I ask for its affirmation by the Senate.
The question is that the Proceeds of Crime, Money Laundering Prevention Amendment Regulation 2019 be affirmed. Those in favor? Against? Minister, may I just say before you proceed that I noticed Senator Brown was asking for, in the future, if possible, that these things be circulated on a timely basis. I must say that that was the refrain of myself in a previous dispensation, which really fell on deaf ears for many years. So I don't expect that you will continue down that road, because past errors don't suggest the correct way forward. Minister?
Respectfully, Mr. President, I cannot allow that to pass. I want to make it absolutely clear that the concern was that we were notified only yesterday that this matter was going to be taken. And I thanked the minister for having, in fact, circulated last night the actual document. I apologized to her when I was critical of her, because I realized it was tabled on the 1st of November when I was absent from the Senate, and that is why I had not seen it. But respectfully, Mr. President, the facts must be adhered to.
Yes.
The complaint was the notification of the deliberation today, and I indicated when I responded to her that we really would have liked to have had a greater opportunity to peruse it more carefully, but that I had I'd given her my word, and I sometimes can't, but I always try to keep my word, if it pleases.
Thank you very much. Minister?
Thank you, Mr. President. And just on the point, to advise that I would have, it's never my intention to give short notice, and there was an administrative challenge with the ministry responsible for instructing me, and it was sorted at short notice. But I did take some comfort from the fact that it had been tabled 2 weeks before, and therefore it's not so much that there wasn't an opportunity to peruse, it is that short notice was given of its placement on the agenda. So, but these things, they occur. If FATF was not next week, we would have more flexibility, and unfortunately that is just not the case. So again, I appreciate the understanding that has been given in the circumstances where it had been tabled 2 weeks ago. So, Mr. President, the next matter on the agenda is the matter of the Terrorism Prevention Designated Reported Entity Attorneys at Law Order Resolution 2019. Mr. President, the resolution, is it 2019 or 2017? Just 1 minute, please. Sorry, it's order the 2017, pardon me. Mr. President, the resolution seeks to give effect to the accompanying order dated February 6, 2017, which in turn imposes certain reporting obligations under the Terrorism Prevention Act 2005 on attorneys at law practicing in Jamaica and carrying out certain activities on behalf of their clients. Mr. President, the Senate will recall that in 2017 we affirmed resolutions in the same terms, but in respect of real estate dealers, casino operators, accountants, and some gaming operators. And the order before us today is the fifth in the same regime. Given the passage of time and change in circumstances in some instances, it is important to just go through briefly the context in which these orders were made and the one today we seek to have it made. Mr. President, Section 14 of the Terrorism Prevention Act provides that an entity will be classified as a listed entity if the entity is designated as a terrorist entity by the UN Security Council, or if the DPP has reasonable grounds to believe that the entity knowingly or committed or participated in the commission of a terrorism offense, or is knowingly acting on behalf of, at the direction of, or in association with an entity so designated by the UN. So, Mr. President, already we're in a different type of context. This is not money launderers at large about whom we don't know their identity and we are uncertain. This is about terrorist organizations that are listed by the Security Council and that are brought into our legislative framework through an application made by the DPP to the Supreme Court and thereafter listed, or where the DPP is aware of certain other circumstances, is able to make the application his or herself. Mr. President, under Section 15.2 of the TPA, there's a provision that certain entities must determine on a continuous basis whether they are in possession or control of property owned or controlled by or on behalf of a listed entity. So again, this is an entity designated as a terrorist entity by the Security Council or by order of the Supreme Court, not property owned or controlled by any client, specifically those of listed entities. So the entities required to make this determination are foreign financial institutions doing business in Jamaica, Jamaican financial institutions, or entities that have been designated under an order such as the one before us today. So, Mr. President, Section 15.3 provides that every 4 months or on request from the CTD of the FID, the entities identified that I've just referred to, that is the reporting entities, shall report to the CTD or a different person as designated by the minister. And the reports should cover that the reporting entity is not in possession or control of property controlled or owned by or on behalf of a listed entity, that the reporting entity is in possession or such possession or control, in which case it should report the number of persons, contracts, or accounts involved and the total value of the property. So again, it's property controlled or owned by a listed entity, a terrorist entity, or any other direction given by the CTD. So, Mr. President, last month the Terrorism Prevention Act was amended, and it should be noted that as part of that amendment, sections 16.2 and 3 were deleted and replaced, and in so doing, addressed some concerns that had been raised by the Jamaica Bar Association in our consultation with them. By clarifying the scope of record keeping and reporting requirements under those relevant sections of the Act, and these cover, Mr. President, FAT F requirements. So 16.1 has been retained, and that provides that all the entities under 15.2, that is including the designated non-financial business providers like attorneys, are guided by these provisions. And Section 16.2 now provides that a reporting entity shall make and retain for a period of not less than 7 years, or such other period as the competent authority shall direct in writing, a record of complex transactions, unusual or large business transactions carried out by a customer with the reporting entity, or unusual transactions inconsistent. But this is the 7-year period is of course aligned with the normal record period that you would require in respect of your income tax obligation. So it does not go further. It's in fact a subset of that, as it's only in respect of complex transactions, etc. So there's it's a streamlining and a simplifying of the requirements here, and there are now clear record-keeping requirements. Mr. President, Section 3A, well, subsection 3 has been deleted in totality, and it's been replaced by 3A, which is in relation to property held by, owned or controlled by listed entities, again, the terrorist entities. So this was not a problem that the attorneys hadn't had a problem with that, and that section is now replacing subsection 3. So again, this is where the property is intended to be used in the commission of a terrorism offense, or is involved with or for the benefit of a listed entity or terrorist group, as I have explained, Mr. President. So, Mr. President, as I mentioned earlier, the orders designating real estate dealers, casino operators, accountants, gaming operators, they were affirmed in November 2017. So these orders took effect in June 2018 because there's a 6-month gestation period which allows for sensitization and general development of procedures, etc., before their implementation. We didn't at that time proceed with the order that's before us now, Mr. President, as we were awaiting the ruling. It was really out of respect, in a way, a courtesy, absolutely, to the fact that there was a constitutional challenge brought by the Bar Association against the Proceeds of Crime Act, and recognizing that there were similar concerns held in respect of the Terrorism Prevention Act's reporting requirements. So, Mr. President, I think it is important, however, for us to make clear that that's a different piece of legislation. There is no challenge brought at this point in time against the Terrorism Prevention Act. It is in respect of the Proceeds of Crime Act. And again, it is largely around the concern regarding the provisions for disclosure of suspicious transactions to a nominated officer or designated authority, where there is some similarity. But again, not only is the legislation different, but the scheme of the acts are different. And this will be recognized on closer scrutiny. So, Mr. President, I note also that the Bar's challenge was dismissed at first instance and now on appeal. There is an interim order pending the substantive judgment, and that it has in fact, the order has stayed enforcement of specific provisions of the Proceeds of Crime Act regime. It has not, however, removed the requirement for compliance by attorneys at law with the regime, or the power of the General Legal Counsel to issue directions to attorneys, or to ensure that they take measures for the prevention or detection or the reduction of money laundering under the POCA regime. So I say this to make clear that while we had put on hold the order as a courtesy and out of respect for a judicial process, the fact is that there is no legal impediment, and even the Bar Association would recognize that there is no impediment that prevents us from proceeding with this matter today, particularly in light of the imminent need to have this order affirmed. So, Mr. President, I want to add also that during this period of time, not only have we had consultations with the Bar Association, and as I've indicated, the amendments to sections 16(2) and 3 were made. In our consultation, we actually indicated to them that these were changes that we would make that would address some of their concerns. And we had committed to doing it, and I since wrote them to indicate that those had been made, and sent them by letter in October that a copy of the bill, and indicating that, you know, we were going forward with the TPA amendments. We had discussed the issue. We had amended the subsections that we had promised to. But of course, you know, we still have these international obligations that have to be met. And of course, I offered in that letter to convene another meeting with the Ministry of Justice and the Attorney General's chambers and them, for us to sit and discuss other concerns or any other options in terms of ways forward. They had previously suggested, made a recommendation, Mr. President, and that recommendation was not one that could be taken on board without sort of fundamentally undermining the governance process. And that was expressed clearly, and they understood, so we see how the matter will unfold. So I will say that I have heard informally that they are planning to mount a legal challenge, and in that context, I can only say that it's important that the Senate understand that we don't have an antagonistic approach to this matter. It's a concern that I understand. Even when the POCA was passed in this chamber and we were on the other side, we expressed our concerns as well, because there are issues. But the Terrorism Prevention Act is different, and it has a different scheme, and it should be looked at. In fact, on the matter of legal professional privilege in particular, Section 13 of the Act addresses legal professional privilege. And the amendment that we have made just the other day creates a new 18A, and 18A subsection, 18 big A, subsection 3, does expressly address one of the fundamental issues with which the bar has a concern in respect of the POCA. So it is the section that deals with the right to take information and documents, etc. And it expressly says in 3, this is of the 18A3 of the Amendment Act, Mr. President, that, that nothing in this section, shall be taken, shall be construed as requiring an attorney at law to disclose any information or advice that is subject to legal professional privilege. And this is, again, the section that deals with the functions of the competent authority in not only establishing measures, but examining and taking copies of documentation, etc. So I really do hope that the TPA, I understand the emotional reaction, because there are concerns about what is a fundamental principle in the practice of law, but that it will be reviewed, that the 6-month period, which stands between now and its actual implementation, also be considered and utilized effectively for further discussions. As I said, I wrote in October and have not yet had a substantive response, only a response confirming receipt of the letter and requesting copies of the additional legislation of which they had become aware. And I had sent that additional information requested on November 1st, 2 weeks ago. So again, our position is not one of disrespect or antagonism or any lack of understanding of the concern, but it is clear that the securing of our financial system is of fundamental importance, and in the context where there is no legal impediment, and in fact, even if it were, it would be, the FATF would not be concerned with that. The fact that there is not, we would be in a truly invidious position to try to explain to them that there's no legal impediment, but as a courtesy, we are not going forward. I think, Mr. President, regretfully, we are at the limits of the courtesy that was extended in 2017. It has been 2 years. The FATF plenary is next week, and it's therefore imperative that we go forward. So, Mr. President, when I led the debate on the money laundering regulations under POCA, I spoke about the importance of compliance, not only in the international interest, but in our national interest. And this is no different. Certainly, it is a challenge to explain, or to even ironic to consider, that your legal fraternity or your, the legal sector would in fact be your loophole or the weakness in your anti-money laundering and counter-financing of terrorism regime. So we have to ensure that we take the best actions in moving forward. We need to ensure that we move out of enhanced follow-up process and unfortunately, time is against us. I don't believe that I need to expound further on the dangers to the financial system, Jamaican financial system, if we are classified as a high-risk jurisdiction, Mr. President. And this is why the matter has come to us today after a 2-year pause out of courtesy. Mr. President, I just will now briefly turn to the resolution and the order to indicate that it relates to attorneys at law who carry out certain activities on behalf of their clients, such as purchasing or selling real estate or business entities, managing money or securities or other assets. And Mr. President, the reference to bank account here is not a firm's account or an attorney's client trust account. It's about bank accounts managed on behalf of a client where they are the agent of the client, not an attorney, not the type of account that would have a particular type of sensitivity. Mr. President, organizing contributions for the creation, operation, or management of companies, again, is about monetary flow and how it can be manipulated and mischanneled or directed. And of course, creating, operating, or managing a legal person or legal arrangement such as trust or settlement, which again is another type of instrument that is prone to being used for the financing of terrorism. So, Mr. President, again, as I said, there's a 6-month period which will allow for discussions with the GLC as a regulatory authority for attorneys, further consultations with the Jamaica Bar Association, should they be willing, as the invitation has already been issued a month ago, and also, of course, other representatives of the legal profession, as they will need broadly to be sensitized about the reporting obligations. And this will be done with the guidance of the FID, as it was with the other sectors, Mr. President. And again, Mr. President, having given the order, I invite members of this Honourable Senate to support the affirmation of the Terrorism Prevention Designated Reporting Entity, Attorneys at Law, Order Resolution 2017. I thank you.
Thank you very much, Minister. Senator Scott Motley.
Mr. President, let me say at the very outset that I will not be supporting the order. My support is not required. I take a different view of the approach which ought to have been adopted in this particular instance. And my own view is that since the requirements are almost identical to that required under the Proceeds of Crime Act, then there ought to be the respect given to the Bar Association and to the court to await their deliberations. I am quite aware that the leader of government business is going to bring to my attention the fact that it has to be listed entities. And for that reason, I want to look at how it is that listed entities are designated, because my recall of it is that an application is made to the court for a designation as a listed entity, or the Director of Public Prosecutions can actually, out of her own accord, make an application to the court indicating that she is suspicious of the movements of these entities and ask for an order to be made. So you can have the listed entities gazetted, they're designated. Pardon me? Yes, there are 2 categories. Now, the argument which is going to be mounted against it is that only attorneys who deal with listed entities are going to be required to make any kind of disclosure. And the report is not necessarily going to be invasive in the sense that The report shall be made to the designated authority at least once in every 4 calendar months, or in response to a request made to it by the designated authority, either that it is not in possession or control of any property referred to in subsection 2, or that it is in possession or control of such property, in which case it shall also report the number of persons, contracts, or accounts involved and the total value of the property. Now, the question which we always go back to when attorneys are required to report is, especially in circumstances where one is not sure exactly the direction which the legislation is going to take, we have to pause to determine whether or not it actually impacts on the legal professional privilege. So that one of the concerns we have is that the legislation does not make it clear, for example, to whom the attorney should report, because the Act actually says that by affirmative resolution, the minister can substitute as a designated authority someone other than the General Legal Counsel. So there's general comfort, Minister, with the General Legal Counsel, because attorneys, they have very strong regulatory responsibilities and authority at this point in time. But as I understand it, the minister might be able to designate others as the authority to whom this report should be made. The other question that one would have is whether all attorneys are required to say that they have to file a report saying that they don't have in their possession or control any property owned or controlled by or on behalf of a listed entity. And I would want some clarity supported around that. Is it that every single attorney practicing, once it is gazetted that you have a listed entity, or once the DPP gets an order that this entity is designated a listed entity, does that mean that the entire profession will have to every 4 months file a declaration saying, I have no control, I don't hold any, I want to get the exact wording, that I am not in possession or control of any property which is referred to. I hear what the minister said about her interaction with the Bar Association. I cannot comment on that since I was not made privy as a member of the Bar Association, because one must remember that one wears different hats. I'm a member of the Bar Association, and as a member of the Bar Association, I am aware that a general meeting is convened for the deliberation of this piece of legislation. And I am aware of legal opinions which have been given to the Bar Association, which makes their concern a very real matter. For my own part, if there has been a suspension for 2 years, I cannot understand why a suspension for 3 more months would make a difference. Because the minister herself said we are sovereign. And being sovereign also means that in complying and demonstrating our sovereignty, in complying and demonstrating our willingness to be part of this international and global designation, in our willingness to demonstrate that we want to keep dirty money out of the country, that we want to keep suspicious transactions out of the country, and that we want to acknowledge the nobility of our country, we also have to acknowledge the concerns of our citizens and the nobility of the profession. And I remind, when I was looking at actually the challenge to poker, I looked at the request, the action brought by the Bar Association for a stay. And the then Solicitor General actually protested and said it was most unusual for a stay to be granted in these circumstances against the Crown. The arguments on both sides were potent and powerful. But at the end of the day, the court said that it wished to, it thought it was important for everybody to appreciate that legal professional privilege is for the benefit of the people and all who seek legal advice and not for the protection of the attorney. And I think that it's important in every possible context to reinforce that, so that the privileges allows all citizens and non-citizens of Jamaica to seek legal advice or legal representation so that he or she can organize his or her affairs properly. So that if there is an entity which is actually asking an attorney, retaining an attorney to create, operate, or manage a legal person or legal arrangement such as a trust or settlement, that entity is also treated in the same way that a citizen of Jamaica would be treated, and they would be required to have the protection of a well-established and sacrosanct privilege. It is clear, Mr. President, that in this world, in this changing world that we made reference to earlier, constitutions are being ignored more and more, and the rights of the citizens are being subsumed under what has been described as a need to have more control and more regulation to create, insofar as it is possible, a perfect society. You will not have a perfect society or a well-regulated society if people do not feel that their rights are also respected. It is people who breach the law, and increasingly, if you whittle away at their feelings that they matter too, you are going to find that you are not going to get a level of cooperation which you desire. So I know that the order will, of course, go through. I myself would have taken a different approach to the presentation. You know, it is not the first time that we are seeing where in this house, we are motivated by the desire to meet a deadline. The desire to meet a deadline, such as in needs. And then the constitutional challenge has actually delayed something which, if proper thought and consideration had been given, we could have actually benefited from the strong points in that legislation. I have had the privilege of wearing many hats. I have been a member of the council, the General Legal Council, which is a regulatory body, and therefore takes a particular view. I have been a member of the Bar Association, which also takes a particular view. And now I have the honor of being a senator. I understand what drives government to get things done. I understand it. I have been a part of the government, and I know those considerations. Today, Mr. President, I cannot feel satisfied in spite of the assurances which the minister has given. And I usually take her word for things. And I'm not questioning her word, but I'm saying that I am not satisfied by the assurances that she has given, that this is of such moment that it could not await the deliberations of the court. And even while I am cognizant of her view that it is not the same scheme and that it is different, I believe that the requirements which are identical The fact that the Jamaica Bar Association is concerned enough to call an emergency meeting, the fact that it is already well established that there is going to be a challenge if it is passed, I am not supporting this.
Time for some delay.
Thank you.
Thank you, Mr. President.
I'm sorry. Thank you, Senator Scott Martin. Thank you, Minister.
Mr. President, just to indicate that I care and understand the position of the Leader of Opposition Business in the Senate, that this I think is quite clearly easily described as being between a rock and a hard place. The fact is that the courtesy was extended for 2 years, not because we felt that the legislation was on all fours with each other, that the issues were exactly the same, but as a courtesy, as indicated. We are now on the cusp of the FATF plenary, and it is not about any lack of understanding about one's sovereignty or about the strength of a country's concerns about its people or about the principles that that guide the practice of the law or the delivery of legal services to the people of Jamaica. Not at all. But we are now 2 years later at the point of the Financial Action Task Force plenary, at which we are meeting with the obligation to report on what we have done to address the issues that were identified back then. Now, were we to stand, and lawyers who understand that technical matters and technical positions make a difference. You can win or lose a case on a technical matter at all, even where the substance otherwise lies in your favor. And to indicate that there is no legal impediment, that is one that a position which even the bar recognizes. There is no action against the government in respect of the Terrorism Prevention Act. The amendments that have been put forward, which specifically provide under 18A3, for example, for the protection of legal professional privilege in the exercise by the competent authority in respect of its ability to take documents, take copies of information, etc. That those make a difference. They are safeguards which we expressly built in. There also being Section 13 of the Principal Act, which already provides for protection in respect of legal professional privilege as well. Mr. President, we have done what we can do. We have extended the courtesies which we could have and have done so for as long as possible. We have extended an invitation which continues to be open to meet with the Bar Association, although admittedly now the order will have been passed. We will be in that 6-month interregnum prior to implementation, which provides its own opportunities for discussion and guidance of the type of guidelines which will be issued and that will deal with the details. Mr. President, there are regulations to come under the Terrorism Prevention Act and under the UN Security Council Resolution Implementation Act that we passed the amendments 2 weeks ago. There are regulations also to come under that act, amended regulations which are aligned with the POCA regulations which we just passed, but the UN Security Council Regulations Implementation Act regulations will affect proliferation financing, and the TPA will, of course, relate to terrorism, financing of terrorism. We may have to sit earlier so that we can hopefully ensure that actions post will still be considered prior to their final issuance of a report. But at this point, we must do all that we can lawfully and legally do in the practice of our constitutional responsibility as a Senate to make laws for the order and good governance of Jamaica. And in such circumstances, therefore, Mr. President, I ask for affirmation of the resolution before us. I thank you.
Thank you, Minister. And the membership have heard the request by the Minister for affirmation in relation to the terrorism prevention designated reporting entity, attorneys at law, order 2019. Those in favor?
President, let's have a divide on it since I've stated my position and I would like it to be on record.
There is a call for a divide. Madam Clerk.
Senator Braham? Senator Brown?
No.
Senator Charles? Senator Crawford? Senator Fraser Beans? Senator Gale? Senator Horton? Senator Hill? Senator Johnson Smith? Senator Knight? Senator Longmore? Senator Morgan? Senator Morris? Senator Morrison? Senator Samuda? Senator Scott Motley? Senator Sinclair? Senator Skeffrey? Senator Webby? Senator Williams? Senator Williams? All right.
I do report the divide as follows: 10 ayes, 6 noes, absent 1, 2, 3, 4 members. So the approval of the regulation is carried. Minister?
Thank you, Mr. President. Mr. President, it is now intended to have the opening of the State of the Nation debate by Senator Matthew Samuda.
Thank you, Minister. Senator Samuda, you may proceed.
Mr. President, I rise today to make what will be my 4th contribution to a State of the Nation debate. In fact, I am proud to be opening the debate. We work as a team, so it's not a problem. I am thankful for being given the opportunity to serve in this noble chamber and must once again acknowledge publicly the confidence vested in me by the Prime Minister, the Most Honourable Andrew Holness, for recommending me to the Governor General that I be appointed to the Senate. Colleagues, politics, political service, government service isn't easy. National service isn't easy. It is our families that bear the brunt of our decision to give of ourselves to the democratic process. So today, I once again make special mention of my family, whom have given of me to serve. I wish to acknowledge the political tutelage of those who I have had the opportunity to serve politically with especially the team from the JLP's Area Council 1, to name a few, Deputy Leader Desmond McKenzie, Chairman Winston Ennis, and my political brother, His Worship Senator Delroy Williams. The constant mentoring from the likes of Dr. Chang, Robert Montague, and Ed Bartlett is noteworthy as well. But finally, my political godfather, President of the Senate, Thomas Tavares Finson. Thank you. But I also must thank my colleagues from the opposition benches, especially Senator Floyd Morris, who has provided more guidance than this chamber would be aware. Mr. President, Mr. President, I have reflected on my time in the Senate as I looked at how I would approach this presentation. It has indeed been a rewarding experience to review the legislation that is being presented to govern the land we love. I wish to briefly mention three things which have been weighing on my mind about how we conduct our affairs before I dive into the presentation. And the first would be, you would notice that I have not circulated printed copies of the presentation as has become practice for State of the Nation debates. I will circulate by email, but it is because the first thing that came to my mind is how we use paper in this chamber. We are having many discussions about a new parliament. We're having many discussions about how we govern, how we manage boards. But we cannot change, or we cannot seek to change this land without changing how we operate. And the fact is, I've done a raw analysis of what I see tabled in the lower house and what I see tabled in the upper house. When you look at things like the order paper, 14 pages today. The agenda for many committee meetings, several pages. Rough analysis, I can see where those two documents cost this country $500,000 a year to be printed, from what I can see. And there are many other documents circulated that don't need to be printed. So I would say to the clerk, I no longer need to receive printed copies of these documents. And for those who can do without, I would ask you to indicate same to the clerk. Let us make small changes where necessary. And agreed. So it needs to be agreed. It needs to be circulated electronically. I have made the same changes at any board that I have the opportunity to serve on. And I'm happy to say it is bearing fruit and saving costs. Ink is imported, paper is imported, and there's the environmental impact. So I ask my colleagues to do the same. Another thing that has been weighing on my mind, and I've said this before in the State of the Nation debate, which would have closed at the beginning of this calendar year, but at the close of last fiscal year, was I extended my hand and I asked my colleagues on the other side to once again start joining us for lunch. The fact is, we will find greater collaboration and greater space for getting things done if we're able to develop a deeper understanding of each other. And one of the best ways to do that is to share fellowship. So I once again extend that invitation. It is not, and it is not that our debates should be any softer or that we shouldn't have the ability to express our disagreements in a particular manner, but there is no reason, in my honest opinion, why we cannot share lunch together. True thing. But, so I once again extend the invitation. The third point and final one before I go into the substantive presentation is the way, or rather the fact that I think colleagues, and I certainly will formally make the request of the leader of government business, I think we will need to look at possibly towards the end of the year or maybe early in the year, looking at a few Thursday sittings so that we don't interrupt the legislative agenda. But there are some motions that are on the order paper that I definitely believe strongly should be taken. When we look at this term of government, not even going back, right? We think of the fact that we had bipartisan support on the motion that brought about the plastic ban,
and we think of Senator Morris's motion that basically set the theme for a Labour Day. So it gives us the opportunity to assist, I think, the Cabinet, the government, in bringing about some necessary discourse and some changes where possible. So certainly you know my position on the tax committee, and well, the tax one, and there's a reason why I feel strongly about the tax one. I don't have any issue with the pension one, but I think the tax one is particularly important. One at a time though, but one at a time. Don't get too excited, one at a time. One at a time, Senator Brown. But, Mr. President, the one point I'll make before I dive in is that the most dangerous phrase in the English language is we've always done it this way. So let us look at things big and small that we can change to improve the lives of the Jamaican people and continue to put the service and the effort that we do on Fridays behind this service. Mr. President, I have followed a consistent format and approach to my contributions in these debates. I've always taken a look at the economy, the environment, and the general well-being, and of course, issues of the day. Now, of course, I have mixed these with occasional political jabs or two. I have listed 2 points following in every presentation of the State of the Nation, in the State of the Nation debate, and certainly in our debates on the national budget. And I believe they're worthy of consideration as you determine the merits of the substance of this presentation subsequently. One is that a rising tide lifts all ships, and the question, are people better off today than they were in February 2016? Yes. Mr. President, allow me to venture into the first section of my presentation dubbed the economy, from poverty to prosperity, from austerity to stimulus. Mr. President, though no history lesson is necessary to those in this chamber, being ignorant of one's past dooms you to repeat it. This is why historical context is important, especially when one considers the age range of our population and just how many of our citizens are below the age of 24 and wouldn't have been exposed to certain periods. I'd like to look at the period spanning my 35 years alive. The 1980s, no, alive, sir, alive. The 1980s were a period of phenomenal economic growth. The main concern of the period, and certainly from the readings that I've been able to go through, was around the inclusivity of this growth and how it was spread. Unfortunately, the period came to an end and was capped off by the ravages of Hurricane Gilbert. You had a change in government. This change in government brought about, well, the inclusivity of it was mentioned. So this was followed by 18 and a half years of stagnation, bad economic policy, and the virtual collapse of the financial sector in the mid-90s because of a savage interest rate policy. Paltry growth rates, averaging at just under 1% a year during that period, capped it off. This is in comparison to the rest of the world, which saw phenomenal growth, Mr. President, during the period, especially our major trading partner just north of us in the United States. This period wiped out a generation of entrepreneurs with more than 40,000 businesses being closed and shuttered. This forced an increased rate of the brain drain, which has eroded much of the cerebral capacity in the country, unfortunately. Largely, this period was responsible for a heavy debt burden which the country faces. There's a Capri study that would have been published in 2008 that spoke to 71% of the country's GDP debt burden being created between 1996 and 2003. And unfortunately, this debt would not have been used to build the capacity for Jamaica. Mr. President, I wish to pause again in this analysis and chastise the government that I'm indeed a part of, supportive of, and generally proud of. However, as it relates to the FinSAC report and the utter tragedy of its non-completion, I am genuinely disappointed. We owe it to the country to complete it and make it available for review. I will leave that there for the time being. Then we came to 2007 to 2011, a period marked by the worst global recession in 100 years. This on the back of the inherited debt burden and several extreme weather events put the administration of the day under significant pressure. Though many strides were made and the economic reform process commenced, Despite these strides, the electorate in their wisdom were not comfortable with our performance and we were replaced. The following administration in 2012 had to come to terms both with the long-standing debt burden and the result of the global financial meltdown, along with severe weather events which continued. They embarked on what was a very tough IMF program, the hardest such one in the world, and they followed the prescription. The program was generally successful in bringing about macroeconomic stability. However, let's make no bones about it. It is the Jamaican public which was asked to pay the proverbial bill. Let's not forget that at the end of that term, in February 2016, poverty had increased to rates above 21%. Unemployment had increased to 13.8%, with youth unemployment nearing 40%. We had leveled just under $6 billion of new tax measures against the people. Tax revenues had missed targets every single year in government. The dollar devalued 39% in 4 years, and suppliers of GOJ goods and services were not being paid on time. One would think of the JPS issue where we cleared a significant backlog, but this is one of many such issues that would have existed. Now, fast forward to February 2016. And the promise of moving Jamaica from poverty to prosperity, a new administration was again brought in on the wisdom of the electorate.
Very well.
Mr. President, it has not been an easy road, but I genuinely believe the country is better off today than it was when we came to power in February 2016. There are several metrics which are used to gauge the performance of an economy and the country at large. Many of these metrics include GDP growth, strength of reserves, interest rates, inflation, employment rate, poverty rates, competitiveness, productivity, and performance of your tax measures. You know, we have been mocked by colleagues regarding the aspirational target of 5 in 4. But, Mr. President, there is nothing to be ashamed of in setting goals and doing the best possibility with the best possible with the capacity you have to hit these aspirational goals. In the budget debate earlier in 2019, I introduced my perspective on the matter. Quite frankly, it is more in 4. Let me explain what I mean by this. No, man, I'm going to go into it now. More in 4. Our GDP, you know, when I touch climate change, I'll explain to you just why you're having so much vector-borne illnesses. Wait, man. School in session. Our GDP, each year that we have been in office, has grown in absolute terms more than the cumulative growth of the past 4 years of the past administration. Wow. Each year. Wow. Jamaica's reserves are historically high, above $3 billion US. Interest rates are at historic lows of 0.5%. Inflation is performing within its target rate and is today at 3.3%, historic for Jamaica. The unemployment rate is at 7.8%, with more Jamaicans employed today, Mr. President, than at any time in our history. Poverty rates are lower today than they were when we took office. And I expect that by the time of the next announcement from Statin and PIOJ, that they will have gone even lower than where they were in 2017. Mr. President, Jamaica, most recently, has moved up 4 spots in the World Bank's 2020 Doing Business report, from 71st to 75th in 2019. More importantly, Mr. President, Jamaica's absolute doing business raw score continues to improve, moving to 69.7 from 68.3 last year, reflecting continuing tax, regulatory, and business reforms, Mr. President. Our tax revenues, no, you're right, Mr. More in 4. We're doing better than we've ever done in many areas. Our tax revenues continue to meet and exceed targets. Colleagues, let's not forget that we have started the process of restructuring our tax system to move in some direct taxes to indirect taxes, and have started cutting burdensome growth-inhibiting taxes. For instance, we've made it cheaper and easier for people to own houses than they have ever done in Jamaica's history. Yes. This administration, Mr. President, quite frankly, has done more in 4. Yes. Mr. President, When we think of some of the taxation structures, and one of them that I'm particularly proud of is the removal of the minimum business tax, Mr. President. This is something that saddled $60,000, I believe it was, annually on small businesses that has been removed, Mr. President. So the truth is there is much more to be done. However, we are moving in the right direction. Mr. President, there's a broad topic which I would like to briefly discuss. That is capacity. Jamaica is investing and being invested in a way that can only be described as unprecedented. We, however, must be honest in our analysis and admit that we in Jamaica are playing catch-up. Our physical infrastructure, IT infrastructure, social services, and human capital all require significant investment to change Jamaica from being middle income to indeed being prosperous as a nation. As we analyze the capacity of our country, it requires political maturity as we allocate both time and capital to attack these problems. This doesn't mean we shouldn't celebrate strides made, but we should always guard against the public's expectation of quick fixes. There are indeed a few reasons to celebrate in recent times, Mr. President, and again it shows we are doing more in 4. Groundbreakings for housing schemes. I mean, I've lost count. A map that I would have seen from the NHT shows that housing is being put in at unprecedented levels right across the length and breadth of this country. More than 20,000 housing starts by next year. And Senator Brown having served on that board. More than 20,000, Mr. President, in 4 years of housing starts. And Senator Brown having served on that board would be fully aware that this is more in 4. I remember in one of Senator Crawford's more animated political presentations, I think it was in 2011, he said that the only hotel room that Ed Bartlett had built was a community center in his constituency. Now, he was in unusually animated fashion. However, Mr. President, however, Mr. President, even Senator Crawford, in his most animated fashion, would have to admit that every time you turn on the news, there's a groundbreaking for more hotel rooms, Mr. President. More in 4. Recent announcements.
More tourists in 4.
And we're keeping more of the dollar being spent here in Jamaica too. That is also a major achievement. Mr. President, recent announcements of yet another call center in Portmore, which will create upwards of 4,500 jobs, Mr. President, is more reason to celebrate. The private sector continues to invest. We would have heard recently of the announcement of CariMed's new facility. We would have also heard and seen the groundbreaking, and this is the benefit of work across administrations, but it is good that it has finally come to pass. The groundbreaking of the new Children's Hospital in Montego Bay. Now, you mentioned the pipeline, Senator Sinclair. Pipelines are important. We have unlocked pipelines, but let's talk about the pipelines in St. Elizabeth, Mr. President. People that have never had running water, Mr. President, in St. Elizabeth, specifically in the project in and around Junction, will now have running water for the first time in Jamaica's history, Mr. President. No man, so I come into that. So the reason I mentioned capacity, Mr. President, is that you have to have the capacity to grow. You have to have the capacity to deliver social services. This is why I mentioned the infrastructure, and I've touched some of the infrastructure projects. There's one I would like to speak to this morning because I'm extremely happy for the people. I used to have to work in the parish of St. Thomas at Surge Island. And Mr. President, I am happy to see videos this morning of the heavy equipment rolling into St. Thomas, Mr. President, as we deliver on the promise for better roads in that parish. This is how you build the capacity for the parish, Mr. President, because that will bring housing, that will bring greater investment. We are building the capacity for growth, and we're building it faster, and we're building more in 4, Mr. President. Very good year. Very good year. Now, we could speak about the town centre. We could speak about, I could pick any one of the housing developments that the ground has been broken. We could speak about the housing development in Frog City. But we are all aware that right across the length and breadth of this country, Mr. President, the infrastructure that this country badly needs to deliver the capacity for growth is being put in at faster rates than it has ever been put in. And you can talk about the upgrade of health centers. You can talk about how many classrooms have been built. You can talk about the renovation of 180 police stations, Mr. President. We are building more in 4, Mr. President. Now, these are certainly not the only capacity issues, President, but I'm speaking to that. You know, what you should call us is Bill Road government, is give people water government, is Bill House government. So you sit there and talk. And that's, okay. Look, your time will come to present Senator Brown. You can wait till you go downstairs for lunch, because I know you're coming down this afternoon. Colleagues, I would like, I'd like you to circulate these for me, all right? This, colleagues, as I move into the next phase of my presentation, is a very important topic to me, because even though we are building and doing what is necessary, circulate one to everyone, thank you. Even though we are building more than ever before and we're doing what is right in the many areas that need addressing in this country, there is a threat that we all face. I've circulated what is called climate stripes, and I'll wait until those, certainly my colleagues on the opposition have. Sideways, it's lateral. So, this way. What you're looking at is called climate stripes. Yes, but worth it. So, no, it's not the. What you're looking at is Jamaica's climate stripes. And what it speaks to is the relative temperature in Jamaica from 1900 to 2018. So, Jamaica's hottest year on record. No, but it's just a relative temperature. So, it shows that we're indeed getting hotter, right? So as we consider the state of Jamaica's environment, it's important that we understand that some factors are outside of our control and some are within our control. However, adaptation is critical to the survival of us as a people. We are on an island, we're an island state where 70% of our population lives within 5 kilometers of the coastline, putting us at further risk from rising sea levels because of global warming. Jamaica, despite its challenges, has taken responsibility for its environmental protection, climate change mitigation and adaptation seriously. Our Prime Minister is being recognized as a global leader in the movement to address climate change. Last year, he was asked by the Secretary General of the United Nations to co-chair an initiative to raise $100 billion for the replenishment of the Global Climate Fund. This with President Macron of France. It is something Jamaica should be proud of. We are responsible ayad and recognized abroad. Since taking office, this administration's major environmental strides have included the shift of our target from the energy mix with 30% being provided by renewables to 50% in 2030. Yes. Recent resignation and announcement of an additional 14%, that an additional 14% of Jamaica's landmass will become protected areas. This with the 14 new forestry orders that we passed in this chamber in 2016, and with the coming designation and finalizing of the cockpit country of over 70,000 hectares, which colleagues should be aware of, will be the largest protected area in the Caribbean. Colleagues, we must be clear. This moves Jamaica to double the international target for protected areas. The international target by the UN is 15%. When this is complete, Jamaica would have 30% of its landmass protected. we have commissioned the largest solar plant in the Caribbean, 51 megawatts to be exact, was brought on stream in Westmoreland, giving you clean, cheap energy, Mr. President. The listing of the Wigton Wind Farm shares, which has provided what I believe is the best example of blended finance anywhere in the world when I've looked at examples. This creates the framework for financing future expansions and for driving the investment necessary for us to put in place clean energy, Mr. President. The LNG conversion of a fuel source in Montego Bay for JPS is another achievement that we should be proud of, Mr. President. Launch of a project being spearheaded and I know pushed very heavily by my colleague Senator Robert Morgan to plant 3 million trees, Mr. President, which will include 3,000 hectares of mangrove forest, Mr. President. Now, there are 3 islands. And we're planting more in 4. But Mr. President, sometimes we don't understand the importance of mangroves. There are 3 islands almost side by side. You can actually see them from each other in Bahamas. 2 had no mangroves, 1 did. The eye of Hurricane Dorian passed directly over all 3 islands. I can tell you, when you look at the overhead picture of the one in the center which had mangroves, it survived. It had no loss of life. The other 2 islands were not able to say that, Mr. President. Mangroves are extremely important to the protection of our coastline, and this is a major step to replace the 3,000 hectares that we've lost over the last 30 years, which has helped erode our coastline badly. Announcements that we will develop a master drainage plan, Mr. President, is absolutely important. Development orders for all parishes nearing completion. Coastal revetment projects in downtown Kingston and in the northeasterly part of the country, Mr. President, is something that we should be proud of because we have to adapt as climate change becomes a reality and a greater threat to us. Now, there's another step that you take, and it's not development of a policy, it's not law, but it was a decision by this government to turn down 2 investment opportunities. Now, when you turn down 2 investment opportunities in a country where you need growth and you've had paltry growth rates for the last 30 years, you have to ask yourself why. But the question is, when we made the decision, rather, to turn down the development of Goat Islands and to not consider putting in a coal plant in St. Elizabeth, Mr. President, it is because we knew that Jamaica's environment is important to the young people of this country and important to our future, Mr. President. It showed those decisions showed courage, showed leadership, Mr. President, and it showed that we will not pursue economic development on the back of environmental degradation. It showed, President, that our Prime Minister will not seek prosperity on the back of pollution, Mr. President. Additionally, we have engaged in significant capacity building for all of our agencies that work in this space. A lot of it funded by our external partners like the IDB, Mr. President, and we must thank them for this continued partnership. The other point which I'm particularly proud of was the phased implementation of a ban of single-use plastic bags, straws, and expanded polystyrene foam, commonly referred to as styrofoam. And, excuse me, I'm going to ask you to distribute those things now for me as well. They're in the box over there. So, colleagues, I've come bearing gifts this afternoon because I am expecting that... Well, put it this way. We enjoyed bipartisan support as we passed the motion that banned these single-use plastic items. And I want us across the aisle to become examples of how we are supposed to use particular materials. So I've brought reusable bags and reusable water bottles for my colleagues in the Senate. And
we're steering government.
Sorry? I don't, but I can arrange for them to get. I will arrange for some to be sent down to your school. All right?
Thank you.
So, Mr. President, I have noted comments from sections of the society and the private sector relating to a request for a delay in the implementation of the second phase of the ban. of expanded polystyrene foam, commonly referred to as styrofoam. Mr. President, I need to put it on the record of this Parliament and state publicly, I have no intention of supporting such a request and consideration for such a request, Mr. President. Mr. President, allow me to remind the nation and indeed the Senate of the chronology. The national discourse on this matter started on Earth Day, April 22nd, 2016, when I announced by way of a press release my intention to pursue this policy path by way of a private member's motion. Varying levels of market consultations commenced then. The motion was passed in September 2016 with bipartisan support. A working group chaired by Dr. Paris Leawai commenced in February 2017. An industry subcommittee was a part of this working group. In fact, opposition members also worked on this committee, and I have to extend formal thanks, even though it's no longer her portfolio, to Senator Fraser Binns, who assisted me greatly with this project. The report from the working group submitted to Minister Vaz, who took it to Cabinet for consideration in September 2017. PM Holness instructed further consultations be carried out. This process came to a close in September 2018, Mr. President, a year later with the final policy announcement. The first phase, and people must remember, the first phase of the ban on expanded polystyrene foam actually came into effect in January 2019, where we curtailed imports of the material, Mr. President. So the ban, the first phase has already started. So, colleagues, if you look at the dates, you can see that the process is indeed over 3 years old. The environmental challenges faced by the nation are 3 years more mature and that much harder to correct. Whereas I will not redebate the reasons for the ban, I believe it important to point out two. One, well, both made in the UN Environmental Programme State of Plastics report in 2018. And why it's important to point these out and put them on the record of the Parliament is because that report would not have been available to us in 2016 when we debated it. One is that expanded polystyrene foam contains carcinogens. Now, I won't get into the medically what that does, but I leave that for your own research. The second point that you should be aware of is that the UN has moved the expectation of biodegradability of expanded polystyrene foam from 450 years to 1,000 years, Mr. President. There is no economic model that even the accomplished economists in the room like Senator Horton would be able to do to work out the cost of storage for 1,000 years without knowing the other factors, Mr. President, of this material. It means that any container or material or lunchbox or cup that we have ever used in this country with styrofoam will be around long after we are not around, Mr. President. It means it will be around for upwards of 1,000 years, Mr. President. So, anything but implementing the policy in line with the dates previously determined would be a retrograde step. This government has displayed clearly an unparalleled commitment to environmental protection and should not backslide. Furthermore, Mr. President, we have some amazing companies in this country who do amazing work that competes globally. The companies that play in this particular category of product, Mr. President, have amazing capacity for distribution. They can assist the government in ensuring that this policy is implemented seamlessly with as little pain and that we get it right, Mr. President. So I look forward to their participation and support and partnership in getting this policy right, because there are other policies similarly which must come as we seek to provide for and protect the Jamaican environment for our children and grandchildren, Mr. President. Though air and soil quality are matters which deeply worry me, because of time limitations, I've chosen to focus on the environmental section of this presentation to the matter of Jamaica's coastal environment. When we consider what I deem to be the main issues we must contend with in this area, we must consider land-based marine debris, increased nutrient flows to the nearshore environment, our coral reef health, fisheries management, and the buzzword and the topic that you hear so much about now, sargassum. Last year, I remember my colleague Senator Kerencia Morrison spoke of green gold. This year, I wish to introduce the concept of blue wealth. You see, colleagues, Jamaica has been blessed with territorial waters which are 24 times larger than that of our landmass. Mr. President, for Jamaica to harness the awesome blue wealth, we must understand that ocean health indeed equals ocean wealth. The Jamaica government is actively pursuing the development of its blue economy through mechanisms such as the National Council on Oceans and Coastal Zone Management, and through its participation on the high-level panel of the Sustainable Ocean Economy convened by Prime Minister Solberg of Norway, where our Prime Minister was again recognized internationally and invited to serve on this panel, Mr. President. But as we consider our blue economy, it's primarily made up of coastal tourism, shipping and logistics, and a small fishery sector. We have successfully built a tourism product based on sun, sand, and sea. However, Mr. President, when you consider the diverse demand and interests of tourists globally, and you think that ecotourism does well, near coast beach tourism does well, you think of sports tourism, you think, I saw even Bishop T.D. Jakes here in Jamaica this week, you think of faith-based tourism. I have never heard, and I'm not aware of garbage tourism, Mr. President. It simply doesn't exist. So our environment and the near coast environment is tied so closely to our blue economy, it's not even funny. But I wish to speak to two areas that give us great economic potential, but where there's great potential, there's sometimes great risk if not managed properly. Fisheries and ocean-based renewable energy. Colleagues, as it relates to fisheries, I would like to make the following points. Fisheries is an environmental issue. Consumption of increased protein from the ocean helps us to lower our carbon footprint, improve nutrition of our people, and reduce imports. Jamaica will need to move swiftly to re-examine and implement new protected areas if we are to improve our biodiversity and indeed increase our fish yield, not just by size, not just by total yield, but actually size of the fish that we are catching. Mr. President, we will need to make adjustments in some cases and implement restrictions on some of our fishing activities that we have not, admittedly, as a country, been brave enough to do. Members of this chamber will recall at the last State of the Nation debate, I had indicated that I would be bringing a motion to this Parliament on parrotfish as it related to a closed season. That research process is now at completion, and at the next convenient time I will bring that motion now that the research has been completed, and now that I've had the chance to visit 11 fishing villages and speak to the fishermen of the country to understand their issues more clearly. Mr. President, there is also an amendment to the legislation which we recently passed that will have to come to this House if we are to access some of the international funds that we are able to access that will develop our fisheries sector. We must remember, this is not just an environmental topic that is good to talk about. There are 17,000 registered Jamaican fishermen, many of whom live below the poverty line. We have a responsibility to get this area correct, and we cannot get it right without approaching the environmental issues that face the space, Mr. President. Now, topics aren't irrelated and we don't operate in a bubble. One of the things we will need to do for the fisheries sector, and will require political maturity and particular discussions, we will have to develop a fueling model that allows for our fisheries sector to be competitive. The fact is, the pelagic flow that Jamaica is blessed with sees, for instance, tuna swim 20 kilometers off of the coast of St. Thomas, Mr. President. That tuna is what we import in canned tuna that we get in Jamaica. It's caught in Trinidad after it swims right past us. And it is because of our fuel being so uncompetitive why we're unable to go out and catch this space. So you could easily develop a deep sea fishing industry which moves the artisanal fishers from your reefs, which is causing so much environmental harm and environmental strain, by developing this. Now, I'm not proposing subsidies. What I'm proposing is that we look at how we fuel these boats and look at a separate tax regime that does not make our fuel uncompetitive so that we can develop a deep sea fishing industry. And when you get deep sea fishing industries, big boats aren't cheap, Mr. President. It's companies that own those. Those fishermen will end up getting life insurance, they'll end up getting health insurance. It is something that we must move to and we must move quickly to get done, Mr. President. The other opportunity for creation of greater ocean wealth and blue wealth, Mr. President, is ocean-based renewable energy. I mentioned the fact that we have created a blended finance structure through the listing of shares. I would love to see this used as we explore greater renewable energy from our near-coast environment, Mr. President. I've seen recent research done that shows we can develop a wind farm off the southern coast of off the southern coast of Jamaica, very close to the Pedro Keys, that will generate significant, cheap, clean energy for this country, Mr. President. And I look forward to that research being made public. Mr. President, these areas and the environment, it's a buzzword. People talk about it now openly because it's on CNN every minute. It's a concern of ours, and we have real environmental challenges from years, not just of mismanagement, but of a lack of bravery to do some of the things that was required. The easy one to discuss, though, Mr. President, is the way we manage our litter. Mr. President, we have a culture of nastiness that we've allowed to continue for far too long. And we also, I mentioned capacity earlier, have simply not put in the capacity required to collect the waste we generate. The last I heard, and I keep getting different figures, we had approximately 80 garbage trucks in our fleet trying to collect the waste that we need. The logistics experts I have spoken to suggest we need close to 200, Mr. President, for you to collect the waste. So when persons say to you, well, garbage collection is an issue, it's an issue. It will be an issue while you have 80 garbage trucks. It is not going to be solved without the investment in capacity. But alas, Mr. President, that investment is being made now. The procurement process of over 100 garbage trucks on lease is taking place now, Mr. President, and I applaud the government for this step. So, whereas we need to put in place the investments necessary for capacity in these issues, there is also a culture change required, which is why I would have brought the bags and bottles for my colleagues, because I am asking those in this chamber to ensure that they're leaders in what must be a cultural revolution in terms of how we deal with our waste, Mr. President. Whenever you go and speak to schools and students, encourage them to recycle where possible. Encourage them to tell their parents that it's not right to throw garbage out the window of a car. Encourage our young people to be the change that we desperately need as we protect against these challenges from waste management, Mr. President. And as I close on the environmental section of my presentation, Mr. President, I wish to bring to your attention something which I'll give more details on. I've had discussions with 3 private sector foundations. I've been discussing it with Waste Management, National Solid Waste Management Authority, the NWA. This year, we will launch a competition for young engineers and logistics professionals that will look at stopping waste exiting our gullies into our marine environment. And I already have commitments of $2 million from private sector foundation that will help us do the pilot projects for the winning competition, Mr. President. Because we require creativity, we require capacity, but we require our young people to participate in the process, Mr. President. So, Mr. President, as it relates to the state of the Jamaican... Looks up.
Mr. President, may we seek the suspension of the standing order so that the member could complete his presentation.
Oh, you couldn't hear me, sorry.
Senator Brown, the question is that we suspend the standing orders to allow Senator Samuda to complete his complexion. Thank you very much. Senator Samuda.
So, thank you, colleagues. Mr. President, so the truth is, as it relates to the state of the Jamaican environment, we have done more in 4. Mr. President, we are moving in the right direction, but must move faster. Now, you cannot speak to the state of the nation without addressing one of the major concerns and issues affecting the entire society deeply. The national concern of crime. It would be unfair of me and remiss of me if I didn't speak to it. Now, you know, there's much to be proud of in many areas of governance. I am proud of the decisions we have made to invest in the national security apparatus at unprecedented levels, the single largest investment in the capacity of this critical area has happened in the last budget and is something we should be proud of. We're investing in mobility, we're investing in the justice system, we're putting in place the infrastructure that the police need to work with, we are recruiting. There's much happening, right? And as we've seen from our many debates since we made the decision as an administration to use states of emergencies as a tool in the crime fighting strategy to try and curtail the issues facing us with illegal guns and issues facing us with gangs, Mr. President, the numbers of murders in the country have still not yet come to the level that any of us in this chamber would be comfortable with, Mr. President. And whereas I am comfortable with the investments being made, I'm comfortable with what I've seen strategically, it will require a redoubling of our efforts collectively to ensure that we break the back of this disgusting, over 25, 30-year-old monster that we've been facing in Jamaica. Far too many of our brothers and sisters have been murdered in this country. Mr. President, there is one area, because I won't go into the full list of investments we've made as an administration in the space, because we've had so many debates in this chamber on national security. But there's an area I would like to make mention of before I close, because it weighs heavily on me. That is the area of protection of the nation's children, Mr. President. There are 3 things I believe we can do to improve their security immediately, and we must do. So I am making that call on the government to ensure that we do these things very quickly, and my colleagues in the cabinet, I hope, will listen and act quickly. One is that we need to ensure, well, no, I don't, sir. I visit occasionally to tell them hello. Ensure, Mr. President, we must ensure our telecom providers participate more vigorously with the Ananda alert system, Mr. President. The other day, to avoid roaming charges, I bought a SIM card while I was abroad. And as you turn the corner, a pop-up would come on your phone when there was a missing child. Certainly the pop-ups took place in the geographic area where the child would have been missing, and I understand that it goes out wider as time progresses. We have the ability through technology to improve the Ananda alert system, and we must do so immediately, Mr. President. That's call 1. Call 2 is that we must increase the penalties with mandatory minimums of 30 years for anyone caught sexually abusing a child or killing a child, Mr. President. Call 3, Mr. President, that the government, we have good tax policy, Mr. President. This is why our revenues are higher than expected and higher than projected. Some of these revenues, Mr. President, as we are in budget season now and people are preparing for the tabling of next year's budget, some of these additional revenues must be used, Mr. President, to ensure that the CDA and indeed CISOCA are resourced in a manner consistent with their importance. We must bring these agencies to first world levels to ensure that our children understand what it is to have first world level protection, Mr. President. Mr. President, that concludes the substantive presentation. I am sure that we have done more in 4, Mr. President. Yes. I am sure that Jamaica is in a better place today, Mr. President, than it was in February 2016. I am sure that Jamaica is being led by the right government. I am sure that this nation is indeed blessed by the Almighty. So, you know, Mr. President, no, we are the greenest government this country has ever seen. No pun intended. So,
can only get greener.
to borrow a phrase, one good term deserves another, Mr. President. Should it please you?
Senator Brown, are you asking for more in for?
Lambert wants more in 4. That's good.
Leader.
Mr. President, thank you very much. Mr. President, after...
One moment, Leader. Senator Samuda, thank you very much for your presentation. Leader. Leader.
Thank you, Mr. President. Mr. President, after such a stimulating and informative and indeed enjoyable presentation, it is not our intention to do any further business today, and I would therefore ask that the Senate be adjourned for a date to be fixed. Thank you.
The motion is that the Senate be adjourned for a date to be decided, and so I ask for those in favor. Those against, the ayes have it. Of course, the Senate stands adjourned for a next date to be announced.
Touch the stage anytime it perform then. Best